Good morning and welcome to 2023. A few things I just need to cover this morning before we hear the evidence, Mr. Maharaj. Yes, first of all, witnesses. The position, I think, is now clear on the website which witnesses we will be hearing from the course of the remainder of this week and next week. I've made the position, I think, fairly clear about which order they'll be heard in. Mr. Donowa is now going to give evidence on Monday rather than Friday. To accommodate him, he's out of the country at the moment. The witness statements from a couple of people from HHSL who deal with the crawler are not required by us, and I don't propose, we've got their statements, we've got the material they provided, and I don't propose to have them called unless someone can persuade me otherwise. That's where we'll be with them. The pathology, you asked, I think, particularly Mr. Peterson asked about the two pathology reports on each of the victims in this incident. We've had photographs from Dr. Pramanik. I hope I pronounced his name right. But anyway, we have a number of photographs from him. And as I indicated to Mr. Peterson and Mr. Mutu, we'll make them available to you both on the understanding that that's to be confined to you for the moment, at any rate, unless you make such application as you think appropriate, to see if that provides you with any additional help. If not, then I would expect that you will just destroy them in the usual way. So those photographs we're going to... right, am I not making it? All right. Those photographs we'll make available to you. They will not, I make clear, appear on the website. They will not be made available to anybody else unless they make specific application to me. There is, as you know, a second pathology report that was obtained on behalf of the families, provided by Professor Daisley, I believe. He has not responded to all of our missives, and I'm not persuaded of the need to pursue it beyond that. So anything you want, Mr. Peterson, I'm afraid you're going to have to get it yourself. All right? So I can't provide you with anything further from that. Still dealing with witnesses, Mr. Fuentes has provided additional material that appears in the supplementary bundle. I am told it now is on the site. Correct, good. He's giving evidence, I believe, tomorrow. OSHA, can I remind you all that at the moment they are not scheduled, save that I have informed the witnesses for OSHA that we require them to attend on Monday of next week, subject to being told otherwise. I make clear that we're in some discussion about the necessity to have them give evidence. Can't take it beyond that, but at the moment they are scheduled, subject to anything further that we, as a commission, determine to come on Monday. Yes, which brings me finally to the Tuesday, which will be the last day upon which we will hear evidence in this session, maybe completely. Mr. Zaid Khan from Enquiry will be giving evidence and a small video demonstration on that Tuesday. I have scheduled in a number of family members who have indicated that they wish to give evidence live. May I make this, in particular I address this to Mr. Ramadar, because I understand you represent and have made it clear you represent a number of different family members. At present, I'm not informed as to whether any of those that you represent would wish to give evidence. Can I say this? I encourage those who are directly affected by the outcome of this inquiry and those who are the relatives, close relatives of the victims of this tragedy to consider giving evidence.
Yes.
I want them to understand that we, the Commission, would regard that as important evidence. We will not, I make it absolutely clear, permit anyone to be cross-examined. They should feel completely at ease to say that which they want to say. What weight we give it is a matter for us, you'll appreciate. But I will not, and I don't want them to feel that they don't wish to give evidence simply because the prospect of facing a phalanx of lawyers who might ask a number of questions which they might find difficult to answer. That will not happen. I will not permit it to happen. So they can write out what they want to say, they can go in the witness box over there and they can read it. We will treat them with the degree of sympathy that they deserve and they'll be allowed to leave. And that's the extent to which they will be taking part, if they wish. I don't want anyone to feel compelled to do so, but anyone who wants to should. At the moment, we have 2 people who have indicated they wish to do so, and if they do on the day, then they're permitted to do so. And that's the arrangement it's going to be in relation to those people. All right?
Chairman, first of all, thank you very much for that. I think it's an excellent opportunity for the families to have a sense of ventilation. And indeed, younger Leah Henry has already produced a statement. It ought to have been forwarded to your commission already. I'm still in conversation with other members of the Kurban family as to whether they wish to do equally.
Yeah, I make it equally clear. It's not an opportunity for them to have a rant about who they think is responsible one way or the other or anything like that. I want to understand what they had to suffer and the circumstances in which, in particular, they awaited the outcome of what they believe to have been a rescue attempt.
Absolutely.
And that's what I'm particularly interested in hearing. As I say, it's not an opportunity to have some rant about, well, it's his fault or that person's fault. I won't permit that either.
Absolutely.
All right.
And we are grateful for that opportunity.
All right.
Thank you so much.
Right, that deals with witnesses and the timetable. You'll have seen from the timetable that we intend to conclude the evidence on Tuesday, the 10th of January. That will leave 3 days for potential closing statements. As I indicated at the outset of this inquiry, I will permit those who were not permitted to make statements at the beginning to do so at the end. At the present time, I am minded to allow everyone to go before the 2 principal parties, that is to say LMCS and Paria. Anybody who has anything to say will be permitted to do so. I will need from you an estimate, please, between now and Friday of how long each person or each team anticipates they are likely to be, so that we can timetable it in. At the conclusion of all of what anyone has had to say, Mr. Maharaj will then address this commission as a final address on behalf of the commission. So that is the current timetable as we see it. Can I add to that this? We, as you know, have been quite anxious to see the habitat itself, and with the cooperation of Paria and LMCS, we understand it is to be removed from the seabed. Unfortunately, for reasons I needn't bother everybody else with, that's not likely to happen until the end of January. So not during this period, which is a little unfortunate since we've indicated we wanted to do it some time ago. Be that as it may, it is being done as I understand. So what I'm minded to do is to schedule 2 days in February for us to return to see the habitat and to have 1 day, I put very much as a tentative day, in the event that we felt it was necessary to hear any further evidence, either arising from the habitat itself related to that or as a result of our consideration between now and that date to recall any particular witness. I'm hoping that that will be wholly unnecessary. But I'm anxious that we should not lose the opportunity, if we thought it appropriate, or indeed if principal parties thought it was appropriate. Those days are the 23rd and 24th of February, so after Carnival and after you've had a day to recover from Carnival.
So you may not be aware, a day is not enough to recover from Carnival.
Well, you might have to do your best.
I don't know if anyone who has recovered within 24 hours participated.
Well, I appreciate your frankness, Mr. Peterson, but Ash Wednesday will have to be it, I'm afraid. Can I make clear, this is tentative, and I will hear representations if it is particularly difficult for any particular party other than recovery. And at the moment, I'm minded to say the 23rd, which is a Thursday, 23rd of February, to view the habitat. That would be an easy day, if I can put it like that, with those who have hangovers. We can view the habitat. And then on the 24th, as I say, a tentative day, that's Friday the 24th, to hear evidence, if necessary. And I will make sure that if we thought it necessary, people will have ample notice that that is what's going to happen. All right? So that is a tentative timetable which we've scheduled in so that everyone can make their arrangements around it. As I say, I'll hear any submissions that there are as to the impossibility of those days. All right. I believe that covers all of the issues I wanted to raise this morning, save the application by Council for Paria for disclosure from LMCS. Can I invite you to, I've seen the correspondence provided by Miss Baird, I believe, yes, on behalf of Paria. Now, can I ask, first of all, if that has been circulated to the parties, if everybody's seen the application that's been made? In particular, have you seen it, Ms. Purcell?
Good morning, Mr. Chairman. Yes, indeed, I have seen that correspondence and application.
Right. Well, unless you've got something to add, Mr. Peterson, to the letter that we've received, can I take it as you?
No, Mr. Chairman. We just thought that in the procedure or the process of assisting the Commission, we thought that since we are focused around the incident and the management of the incident thereafter within that 48, 72 hours, we thought that all communication, including, and since you have recognized that LMCS is a party with standing, and as you had indicated even on the closing statements, that they are the two focused parties, that how they dealt and communicated with respect to the communication of what they had, because there's a big issue in this commission as to whether they had a formulated plan and what they did with it and all of that. So I think the communication between them, not the position that they may have taken at the commission, but the communication between them at the real time, which would have been the 48 to 72 hours after the incident. I think that will be helpful to the commission to determine how things were actually done.
So that everyone else understands what's being asked for. I mean, the application was orally made in brief by you before we broke up last year. And the follow-up correspondence from Ms. Baird, who instructs you, asks for all records and or documents produced by LMCS personnel involved in the rescue and or recovery efforts from Friday the 25th to Thursday the 3rd of March 2022, and identifies specific emails and other correspondence. And then B, all records and or documents received by LMCS personnel from third parties in relation to the aforesaid rescue and or recovery efforts. And then any emergency response plan. And then sets out it's important to properly interrogate this allegation that they were prepared to have divers enter the pipe, and to understand the circumstances surrounding the decision so to do. Pausing there for a moment, it seems to me that this was a matter that could well have been identified at a much earlier stage, and I simply wonder why this application is being made now, following the oral application at the end of the inquiry last year, rather than at an earlier stage. I see the identification of particular material and why it's decided that it would be important to this inquiry to have it for the purposes of interrogating that allegation. But given that those witnesses have now already given evidence, I don't know how you're going to interrogate at all without looking at the material. I mean, assuming the material threw up some issue that you thought was relevant or important, Mr. Peterson, you haven't got a witness now to cross-examine about it.
We don't have the material, so but if that material does exist, I think under your edict earlier in these proceedings with respect to disclosure of all in your possession that reasonably would have been of assistance to the terms of reference of the Commission, that would have been forthcoming and should not have even give cause for us to generate this request. So I think that if it does exist, that is something that should have been voluntarily given to your Commission.
All right, well, let's hear from Ms. Prasad Maharaj then, please.
So, Mr. Commissioner, as has been just indicated by you, LMCS's personnel have already given evidence in this proceeding in the live evidential hearing. But in addition to this live evidential hearing, all the parties and particular persons who have not been called were interrogated and went through that process of dealing with all of the issues in relation to plans and everything that would have coincided with plans, decisions, discussions. Now, the evidence is already on record.
Pause, please, for a moment, so that I understand where we're going.
Yes.
First of all, do you concede any of this exists?
Well, it doesn't, and that's why I was now going to go into the evidence, because...
Pause for a moment.
Yes.
First of all, if it doesn't exist, it doesn't exist.
It doesn't
So
exist.
there's not a lot of point in us debating whether it should be disclosed or not disclosed or why or any of those things.
Yes.
Either is in existence or it is not.
There are few documents which were emailed, and those are already part and parcel of these proceedings. So whatever could have been disclosed have already been disclosed, and whatever could have been interrogated has or have already been interrogated. Both at this live evidential hearing and at the interview interrogations, which would have taken place between October to November.
Yeah, so that I'm clear.
Yes.
All right. Your instructions are, having considered the specific requests that have been made, is that if anything existed, it has already been disclosed.
Yes.
And if it's not been disclosed, it simply does not exist.
That's correct.
Right. All right. Yes. Well, I don't think we need to take it any further.
I concede. I'm grateful.
Mr. Peterson, you'll make such observations of that fact as
Yes,
you
sir. Well,
seek to choose to do so.
That's exactly the focal point, sir. If we requested this, if it doesn't exist, it doesn't exist. The only way it falls to be disclosed, and the earlier point I made is that if it existed, then it ought to have been disclosed at your earlier invitation. So if the assertion, if the instructions from counsel is that it doesn't exist, then it doesn't exist.
Yeah, quite.
Because we only requested what exists, and if it didn't exist, then it falls by the way.
All right. Well, we needn't have any further discussion about it. As I say, you'll make such observation of that as you will.
As I will.
As you choose, yes.
Thank you, sir.
All right. Well, look, thank you very much, everybody. That disposes of that. Does anybody else want to say anything about that? No? All right, good. Well, then, why don't we get to the evidence? Mr. Maharaj.
Yeah, Mr. Chairman, the witness would be Mr. Mustaq Mohammed, and Ms. Vijaya Maharaj will read a summary of that evidence.
I, Mustaq Mohammed,
solemnly swear
that
the evidence
I shall give to this commission
in
this case
shall be the truth,
the whole truth,
and nothing but the truth.
Thank you.
Good morning.
Good morning, sir.
Thank you for coming. The water's there for you. You've done the right thing, brought yourself into the desk and brought the microphone closer to you. What's going to happen now is this. You, through lawyers, Miss Baird, I believe, prepared a statement on the 7th of October of this year. That statement has been summarised, and Miss Mirage, thank you, Miss Mirage, is going to read a summary of that statement, all right?
Good.
So please listen to her summary.
All right.
If you agree it at the end, then hopefully you do, we can then proceed to any further questions. If not, you'll point it out to me, all right?
Great.
Any issues that arise, please raise your hand, let me know, and we can proceed from there. Wherever a document is referred to, including your statement, I hope you'll be given it from our team that sits behind me here, all right?
Great.
As I say, if you need anything, just let me know. All right, Ms. Maharaj, thank you very much.
Thank you. Mr. Mohammed provided a witness statement to the Commission dated 7th of October 2022. It's in the witness statement bundle at page 1440. Mr. Mohammed had declined to be interviewed by the Commission. Since August 2019, Mr. Mohammed had been the Terminal and Trading General Manager of Paria. Paria's day-to-day operations are carried out by its employees as well as employees of Kenson, who are deployed by Paria in its HSEQ department, which is the Health, Safety, Security and Quality Department, as well as its maintenance and operation departments as subordinates to Paria officials. Paria has engaged Kenson by way of contracts. Paria's workforce, as of the 25th of February 2022, comprised 95 employees of Paria and 183 employees of Kenson. The HSEQ, maintenance and operations departments were the main departments involved in facilitating and overseeing the execution of the project by LMCS. Paria did not possess the specialist skills and expertise to perform subsea maintenance works, and therefore it was necessary to outsource the works to a competent, experienced specialist contractor. LMCS was hired for the 2021 project after undergoing a process of selective tendering in accordance with the State Enterprise Performance Monitoring Manual and Paria's procurement policies and procedures. LMCS was the sole bidder who was found after evaluation to have submitted a technically compliant and suitable bid. Its commercial submissions were evaluated and also found to be compliant and suitable. A recommendation was made by Paria's Technical and Maintenance Department to Paria's Management Tenders Committee for LMCS to be awarded the contract for the 2021 project. And that recommendation is at the core bundle of documents, page 928. Mr. Mohammed is a member of that committee, which reviewed, discussed, and approved the recommendation and awarded the contract to LMCS. Between 2015 and 2018, LMCS carried out at least 17 jobs, in respect of which LMCS was rated by Petrotrin as acceptable. Between 2019 and 2021, LMCS was engaged by Paria for approximately 7 jobs, which they successfully completed, including a 2020 project involving repairs to number 36 Sea Lion Riser at berth number 5, which was similar to that of the 2021 project. LMCS's performance in that 2021 job was evaluated by Paria in several categories as being very good or excellent. Mr. Mohammed states that LMCS was therefore not only a competent and experienced specialist contractor, but they ought to have been very familiar with the Paria's policies, procedures, and practices. On July 2, 2021, during the course of pre-work at Paria's offshore services dock, a critical injury was sustained by one of LMCS's workers.
This led to OSHA issuing a prohibition notice on the 6th of July 2021, and that notice is at the core bundle of documents, page 1173, pending Paria's compliance with OSHA's requirements for work to resume. Mr. Mohammed appointed an investigative team on July 7th to investigate the matter. The investigators concluded that the incident was caused, among other things, by certain breaches of Paria's permit to work procedure and made several recommendations for actions. Paria's investigation report into this incident is at the bundle of submissions, page 5126. Mr. Mohammed states that the recommendations were accepted and implemented or in the course of being implemented by Paria. Mr. Mohammed learnt about the incident on 25th February 2022 at around 3:15 p.m. from Mr. Colin Piper. His involvement in the aftermath of the incident included performance of his duties as general manager, liaising with the incident commander, Mr. Colin Piper, and requesting and facilitating access by the incident management team to the resources required to assist in an emergency response, and liaising with the divers' families, Paria's chairman, and other stakeholders with a view to keeping them apprised of material developments. On his way to Paria, Mr. Mohammed requested Paria's communication lead, Narissa Fevic, to join him at Paria, as he wanted to start communication with the divers' families and the public. He also informed Paria's chairman, Mr. Paul Newman, and the chief executive officer of Heritage, Arlene Chow, of the incident. He also had a number of exchanges with Mr. Piper on his way to Paria. Mr. Piper informed him, among other things, that a diver was recovered from within the chamber. Mr. Mohammed arrived at Paria at about 5 p.m. He was informed that rescue divers were entering the pipeline in search of the missing divers. At that time, there were several unknowns, and therefore Mr. Piper held the position that it was unsafe to dive into the pipeline. Mr. Mohammed supported this view. Mr. Mohammed was also informed that LMCS's persons at the site were becoming anxious, emotional, and hostile, and he became concerned that persons supporting the rescue operations may be in harm's way, and that search and rescue operations could be disrupted. Mr. Mohammed indicated to Mr. Piper that the Coast Guard were the best persons to protect Paria and Kensington personnel, to assist with the search and rescue efforts, and to control the site with a view to ensuring that the search and rescue efforts proceeded safely and efficiently. At approximately 6:24 p.m., Mr. Mohammed made a request to Mr. Piper for the Coast Guard to take control of the site at berth number 6, and Mr. Piper agreed to his request. His expectation was that the Coast Guard would work with Mr. Piper to plan, develop, and implement plans to attempt to rescue the divers. He also expected that they would have made their presence felt on the LMCS's crane barge so that there would be some respected authority on site, and they would prevent divers from entering into the pipeline in an unsafe manner, as no specialist advice had been received that it was safe to enter the pipeline. However, Mr. Mohammed states that he could not recall whether he actually spoke to the Coast Guard and requested them to assist. Mr. Mohammed said that in the wake of Christopher Budram's retrieval from the pipeline, the main focus was to inspect the internal condition of the line with the assistance of video footage, and as nighttime approached, the divers stopped diving on their own accord. At around 7:45 p.m., Mr. Mohammed heard Mr. Piper speaking to Kazim Ali Sr. on the phone. Mr. Piper asked whether the divers' families were informed of the incident, and Mr. Ali Sr. confirmed that they were. Mr. Ali Sr. requested of Mr. Piper for the topside riser to be installed at berth number 6 in order to mitigate the risk of compressor failure and facilitate the use of tools like the crawler inside the pipeline. He also requested that the blind flange be removed from berth number 5, as he had heard reports of knocking at berth number 5 and wanted to enter from that berth to attempt a rescue. Mr. Piper agreed for LMCS to install the topside riser, but indicated that he would get back to Mr. Ali Sr. in relation to the removal of the blind flange. Around 9:15 p.m., Mr. Mohammed was advised by Chantal Ramdeo, Senior Process Engineer at Heritage, that the removal of the blind flange at berth number 5 could cause any existing air pockets in the pipeline to move or be extinguished, but she could not answer the question definitively, as she did not have all the necessary information. Based on this information, Mr. Piper decided that it was too risky to the missing divers to remove the blind flag at that stage. Mr. Mohammed agreed with this position. At around 9:30 p.m., Mr. Mohammed stated that he called Dr. Miriam Richards to assist with the incident management team having an interview with Mr. Budram so that more information on the incident and the condition of the pipeline could be obtained. At around 9:43 p.m., the incident commander had a discussion with Mr. Piper wherein Mr. Budram provided information in regard to the state of the other divers and the pipeline. At around 10:30 p.m. to around midnight, the Coast Guard concluded that it was too risky to dive into the pipeline. By midnight, there were a number of specialist diving companies with confined space rescue capability, as well as the Coast Guard representatives on site. The incident management team was also having discussions with the heritage team who was providing support. At around 1:30 a.m. on Saturday, Mr. Piper reported to Mr. Mohammed that the data received from the pushrod camera borescope footage was viewed with the Coast Guard and 2 rescue diving contractors, and they all indicated that they would not enter the pipeline to perform a rescue due to the risks involved. At approximately 4 a.m., Mr. Mohammed was informed by Mr. Piper that attempts by a crawler to get past the blockage was unsuccessful. Mr. Mohammed left Paria at about 5 a.m. and returned at about 7 a.m. on Saturday. Mr. Mohammed was informed that after reviewing the information from the borescope and crawler footage, none of the rescue companies were willing to enter the pipeline to attempt the rescue. As such, Mr. Piper indicated that further opportunities for rescue were being developed by the incident management team. However, those options, including the cutting of the horizontal section of the pipeline to create a hatch for the divers, to create an escape hatch for the divers, was deemed to be too risky and not feasible. Also, Eastern Emergency Response Services indicated that the drive rescue option by pumping was too risky, and they now considered the operation to be a recovery and would therefore not enter the pipeline. The incident management team, however, agreed to continue with pumping out the line option in the event that Eastern or another company could be persuaded to execute a confined space dry rescue. From around 12 noon to about 1 p.m., Mr. Mohammed and other members of Paria management team held a meeting with the divers' families. The purpose of this meeting was to give the families an update on the situation and ongoing operations. Minister Stuart Young was present, and at that meeting, Narissa Fevic, Paria Communications lead, was also present at the meeting and obtained the contact information for the relatives of each diver. And by 3 p.m. on Saturday, she formed a WhatsApp group to provide the families with timely updates. She offered the divers' families assistance, including free counseling services and the purchase of groceries, which was accepted by some of the families, but not all. From around 4 p.m. to 4:45 p.m., Mr. Mohammed attended a meeting with Mr. Piper, Mr. Michael Wee, as well as heritage officials. Mr. Mohammed addressed the meeting by providing an update of where the efforts were and indicated that they were working with the option to pump down the line so that a dry rescue could be performed. In addition, the likelihood of the divers not being alive and the potential transition from rescue to recovery were also discussed. After the conclusion of the meeting, Mr. Mohammed and Mr. Piper discussed whether time had come for Paria to make the decision to transition from rescue to recovery based on all the information received. At paragraph 97 of his witness statement, Mr. Mohammed outlined the relevant factors which they considered. A joint decision was made by Mr. Mohammed and Mr. Piper at about 5:15 p.m. to transition Paria's response from rescue to recovery. However, Mr. Mohammed indicated that they agreed to speak with the families first before informing the public. Mr. Mohammed met with Mr. Kazim Ali Sr. at 5:30 p.m. at the shipping building. He told Mr. Ali Sr. that the likelihood of the survival of the divers was low and that they should talk to the families and advise them of this. Mr. Ali Sr. said that that was a message he could not deliver and that he didn't know how to tell them the chances of survival were slim. Mr. Mohammed says he asked Mr. Ali Sr. to accompany him to the families, and Mr. Kazim Ali Sr. suggested that they meet with Kazim Jr.'s wife, and they did so. At around 6 p.m. to 6:30 p.m., Mr. Mohammed went to the house of Kazim Jr.'s wife and informed her of the decision. It was a difficult meeting. However, after the meeting with the Ali family, neither Mr. Kazim Ali Sr. nor any other representative of LMCS was willing to accompany Mr. Mohammed to visit the other families. Mr. Mohammed was informed that the divers' families were gathered outside Paria's gates. He returned to the Paria's main building to attempt to get the families to come inside one by one in an orderly fashion. However, they refused. Mr. Mohammed says, therefore, that at approximately 8 p.m., he held a WhatsApp call to inform the other families of the decision to transition to recovery and the reasons for that decision. Mr. Mohammed states that around 9 a.m. on Sunday, the 27th of February, he met with Paria's chairman, Newman George, and then he and Mr. Piper met with Minister Young and the CEO of Heritage, Arlene Chow, and informed them that Paria was transitioning to recovery. Mr. Mohammed and other Paria representatives held a meeting on Sunday morning with Kazim Ali Sr. and other LMCS representatives. During the session, Mr. Ali Sr. stated, among other things, that he knew his son had already passed and that he was thinking about the recovery of his body and those of the other families, and he expressed concern that the way Paria intended to recover the bodies may cause them to become mangled, and indicated that this is why he wanted to send a diver into the pipeline to bring them out. Mr. Mohammed states that he requested a method statement for the proposed LMCS plan to recover bodies with a risk assessment and emergency response plan and the diving certification of the diver whom they proposed to deploy so that Paria's experts could review the documents and assess the procedures, its risk and mitigation measures before making a decision. Paria received LMCS's documents around 2:20 p.m. on Sunday, after which a meeting was convened with LMCS to discuss the rescue plan. Mr. Krishna Fuentes, independent dive expert, Mr. Rolf Seals, dive experts on behalf of Heritage, and Lieutenant Hargreaves of the Coast Guard did not agree with the proposed dive into the pipeline and indicated that the plan was too vague and risky. Mr. Mohammed and Paria held a conference at about 8 p.m. on Sunday to inform the public of transition to recovery. Mr. Mohammed, is this an accurate summary of your evidence?
Yes.
Thank you.
Thank you for that. Can I just ask you one thing before Mr. Maharaj asks you any questions? You declined to be interviewed by the Commission of Inquiry in advance of this hearing. Are you able to say why?
I think the logic behind it is that, I wanted to be interviewed, have one clear, concise statement around the activities around the incident, and I thought that this would be the best avenue to have that done. And that was the simple reason why we declined to have the interview earlier. So I'm prepared today to go through the extent of the interview as the Commission required to give all the evidence that I could give.
I mean, you understood that the purpose of that particular approach to this inquiry was to try and save time in a public hearing, going through the sort of questions that might have been established in advance.
I give it some thought, and I kind of resolved myself that this was probably the best way to do it.
Was that an independent decision made by you in relation to your own position?
I think it was in consultation with the legal team also, so there was both consultation and independent decision.
I don't want to hear what they might have advised
I just say,
you, but,
yes.
But it was, having taken advice, you decided that it was an appropriate course to take.
Correct.
And was that one which you, given your role in Paria, advised other members of staff of Paria to also adopt?
I would say generally, yes, we all agree that, we'd give evidence once, give it as clearly and as concisely as we can, and we would respond in writing to any questions that the Commission had.
All right. Thank you.
Okay.
Yes, thank you. Mr. Maharaj.
Much obliged, Mr. Chairman. Mr. Mohammed, I want to ask you some questions.
Yes.
According to your statement
Yes.
that you gave, as you stated at paragraph 4 and 5, that as general manager of Paria, your duties included an overall sort of responsibility for safety
Yes.
and secure operations. Am I correct?
That is correct.
Correct. And according to paragraph 5.2 of your statement, the words you use is driving a safety-first culture was the sort of motto that you operated on.
Yes.
And then at paragraph 15 of your witness statement, you stated, and I'm a bit concerned about this, and I want to get some answers from you because I think it's very important. You stated that Paria did not own the necessary equipment, nor did it have the specialist skills and expertise required to perform such a job.
That is accurate.
And you maintain that today.
And I maintain that today.
And then at paragraph 17, you stated that LMCS was hired and there was an evaluation process. And Paria was involved in that evaluation.
That is correct.
And Paria found that the bid submitted by LMCS was technically compliant and a suitable bid.
Yes.
Well, I'm concerned, and I want you to help us. If Paria did not have the expertise required to perform such a job,
Yes.
it also undertook to evaluate the bid in order to determine whether Paria should be, as to whether LMCS should be awarded a contract?
That's the question.
Yes.
Yeah. So I agree with the statement above that Paria did not have the skills. I'd start by saying that I don't believe any organization has all the skills to execute every bit of work that it is going to do. Paria is no different to any other organization from that respect. We'd have gone out with a process where we would have identified the scope, we would have identified the challenges around doing the job, and we would have gotten returns from contractors. In the evaluation process, what would we have looked for? We would have looked that the company had certain management systems in place, that they had an HSE management system in place, that they were certified and deemed competent. In this case, one of our key expectations from people who do high-risk work is that they were STO certified, which is an indication that they have met a certain standard on the performance of work with regards to safety. We would have looked at the general competence of the people and the people supplied to do the job. We would have looked at the ability of the company to do the job. We would have looked...
Sorry, I'm trying to write this down. So
too fast. Sorry.
Just a bit too...
Okay, sorry about that. And we would have looked at the company's track record in being able to execute this type of job. And in all cases, particularly, in my view, there is no better proof of competence than having done a similar job successfully. And LMCS met those criteria. In each case, they were able to meet the criteria. They had done a very similar job on the same section of line only a year ago. I think it's 2020. So they would have met, I would say, the general requirement for being able to execute a job of this type.
Okay, I'll come back to the similar job matter in
Great,
a short
okay.
while. But you will appreciate,
Yes.
and tell me if you agree, that the contracted works in this case that we are concerned about involve a dangerous operation in that there could have been a delta P hazard and persons could have got injured and persons could have been in difficulties. It was a dangerous operation.
My understanding of the job that was done in 2020, that possibility also existed, that there were plugs inserted in the line, there was likely to be a delta P activity. So, in terms of the differences in the job, would it be the depth underwater, I guess the length of the pipeline, but there were no major material differences with regards to the type of job and the risk associated with the job.
So, Mr. Mohammed, you recognize that in this job that had to be done, there was the possibility of a delta P hazard?
I would say at the time of investigating the tender, no.
No. So, having Paria not having the expertise, as you said,
yes,
to do this kind of job, Paria, according to the permit work procedure of Paria,
yes,
was required to determine whether to accept or reject LMCS method statement for these works.
Is that a question? That's a question?
Yes. Paria had to determine whether to accept it or not to accept it.
From the perspective of the permitted work system, all right, every contractor that we hire to do specialist task is expected to bring to the table the specialist risk involved in doing that job. All right? Paria's permitted work system would take into consideration both the obvious risk that Paria has to manage based on the things that we do day to day, and it would also combine that together with the specialist risk that is brought to the table by a specialist contractor. As I indicated before, I don't think there's any company in the world who understands every bit of risk for every job that they do. So there's an expectation that a specialist contractor will bring forward special risk associated with the execution of that job.
I accept that.
Okay.
But the fact is that whatever the contractor does, whatever LMCS put forward in this matter,
yes,
Paria had to determine whether to accept the method statement or to reject it.
Paria had a role in terms of doing two things, according to the permit to work system. We had a role to ensure that there was process set up where the risk was discussed between the contractor and the operator for doing that particular job, that a risk assessment was developed where the knowledge of the contractor and the knowledge of the operator is brought to bear onto the risk assessment. Paria obviously would consider the risk that is evident to them and they could clearly identify, and there has to be an expectation that the contractor would bring those specialized risks to the table.
Yes, but do you agree that in this matter, Paria accepted the method statement LMCS did in respect of this work?
I won't agree with that in the manner that you are presenting the question.
Well, it's accept is either accept or reject.
I'll reject.
Did Paria reject it?
I reject it, but I also want to add.
No, the question is, did Paria reject the method statement?
I would add context to the answer. It's not as simple as accepted or rejected without understanding context.
Well, you're perfectly entitled to add context, and I will permit you to do that, of course, and you must. But it's a straightforward question, isn't it? Either you accepted the method statement or you didn't. Just a minute.
Sorry.
If you say you didn't, then I need to know why you say that you didn't, when all the evidence points to the fact that you did. Secondly, if you did accept the method statement and you wish to add a rider to that, then you have to accept that you accepted it, if you see what I mean, and then you get your opportunity to add the rider. All right? So that I get a clear note of what you're saying, please answer the question first, then give us your rider. All right?
So we accepted the method statement. LMCS was hired to do the job. all right?
Sorry?
We accepted the method statement. LMCS was hired to do the job. That's the fact.
Okay.
Right? However, the acceptance of the method statement and other pre-activity before the job started required that a process of understanding the risk that would come with this specialized work would have been brought to the table. That would be the expectation on the acceptance of the method statement, and I want to make that clear.
Next question.
Before you do,
Sorry.
brought to the table by whom?
By the specialist contractor.
Right, thank you, got it.
Did Paria accept the risk assessment done by LMCS in respect of these works?
And the answer would be Paria would have accepted the risk assessment.
Yes.
But I would also caveat to say that in that risk assessment done by a specialist contractor, the expectation is that that contractor would have brought the relevant risk to the table, the risk that Paria would not have been obvious to Paria, so that a discussion could be had and mitigations against that risk would be put in place. Let me also add that there was mitigation against that risk. There were three. There were two solid barriers and an administrative barrier to help to manage that risk. So I just want to make sure we add that so we're very clear.
Yeah. I'll come to some of that.
All right.
Okay. Did Paria accept the job safety analysis done by LMCS in respect of these works?
Paria would have accepted on the condition that the specialist contractor would have brought specialist knowledge to the execution of the job.
Okay. Did Paria also accept the emergency response plan submitted by LMCS for these works?
Paria would have accepted the emergency response plans based on the credible risk that was identified by the contractor as part of the job. And let me explain what credible risk is. All right? Credible risk is a term that we use in industry to identify the risk that the contractor and the operator see as credible, without understanding the concept of a credible risk. You know, it would almost be saying that, let me use a little bit of an example that might be way out. Should Paria have been we work in the sea, so would we have planned for a tsunami on that day? That would not have been a credible risk. Okay. And this was not identified as a credible risk by the specialist contractor.
Okay. Would you agree with me that in all of the documents relating to the method statement,
yes,
the risk assessment, the job safety analysis, and the emergency response plan, which Paria reviewed, LMCS did not identify in those documents a delta P hazard?
I agree with that.
And Paria accepted those documents?
Paria accepted those documents on the condition that we hired a specialist contractor who would bring specialist knowledge both on safety and the execution of this particular type of job.
We'll come to that. We'll come, because you're saying that, and I accept what you're saying.
Okay, great.
We'll come to that. I'll show you the permit to work rules and what.
It's fine.
Okay. So, Paria, in doing its review,
yes,
did not also identify for these works a delta P hazard.
That is correct.
That is correct. You would accept that from your knowledge, that from what you know now, that there was a delta P hazard, a latent delta P hazard from the 13th of February.
I would accept that we had a Delta P event and there was a hazard of Delta P with this project.
You would be familiar with
again, sorry, I do need to be clear.
Yes.
Are you accepting that there was whether you identified it or whether LMCS did or not, irrespective of that, do you accept now that on the evidence there was a latent Delta P hazard from the 13th of February?
I would accept that there was a potential for a Delta P incident or a Delta P hazard at this time, yes.
From the 13th?
From the 13th?
Yes. The 13th is the day upon which the first works took place in relation to this piece of pipeline. In other words, they did the works on berth number 5. 6, sorry. Intervening Christmas period has confused me which one it is. So once the works had started, there was in existence a potential Delta P hazard. Do you accept that as a fact now?
I'd accept that as a fact with a caveat too, if you don't mind. That I explain a little bit, right?
Whatever caveat you like. Yes.
All right, good. The fact that we would have had differential pressures because of the hyperbaric chamber and the pipeline, right, would have, in hindsight, would have created the potential for a differential pressure condition within the pipeline. I accept that.
From the 13th?
From the time the hyperbaric chamber...
Not before the hyperbaric chamber was
if the hyperbaric chamber was never pressured. Remember, the Delta P was created only during the pressurized period of the hyperbaric chamber. Once the hyperbaric chamber was not in place, then the pressure above the plugs and below the plugs was the same. The pressure potential that created the DP came about with the pressurization of the hyperbaric chamber.
I understand what you're saying. And sort of for my note,
yes,
your position is this, that with the benefit of hindsight, there was a Delta P issue from the time that the hyperbaric chamber was put in place.
And pressurized.
And pressurized.
Yes.
Thank you.
I'd just like to intervene here. I'd like to offer you the Delta P existed when the pipeline was empty, not necessarily when the habitat was put on.
I don't accept it, right? And I don't accept it because both sides would have been at atmospheric pressure. And if both sides were at atmospheric pressure, then where was the pressure differential?
Yeah, I understand where you're going, and I'm not going to argue it, but once a pipeline is dry, right? Yeah, you'd have that differential pressure with all the water wanting to rush into the pipelines. Really pretty basic. So I'm not going to argue it.
Good.
Pipeline empty, Delta P exists.
All right. I don't accept it 100%.
No, I understand. I understand your position. I'm going to leave it to Mr. Maharaj to ask you questions about it because I anticipate he's going there.
Good.
But so that we're clear, your current position is that there was a latent delta pressure issue, but that only arose once the hyperbaric chamber was placed over the open end of the pipe and pressurized. I got you. Right.
Mr. Mohammed, I want to take you to the permit to work rules of Paria.
Yeah.
And that is in Core Bundle 1. It starts at page 26, but I want to take you to page 30. You would agree with me that the site authority under the rules was Paria.
Just now, let me just get my brain in the document here. Yes.
You would agree with me that the site authority in respect of these works
yes.
was Paria?
Yes.
Correct? If you go to 5.3, the site authority shall, you see, it said the site authority shall ensure that a suitable and sufficient JHA has been prepared for the job.
Site authority shall. Okay, good. Yes.
The site authority shall ensure that a suitable and sufficient job hazard analysis, JHA,
Yes.
has been prepared for the job.
Yes.
Correct? You agree with that?
I agree with that.
And a sufficient job hazard analysis for this job would include stating that there was a risk of a delta P hazard.
I agree with that.
You agree with that?
Could I add context too?
Yes.
Now, I want to bring what a permit to work system is, right? A permit to work system is not simply documents that you fill out. It is a process by which an operator engages the person or the company that is going to execute work to develop these exact documents that you speak about. The JSA, the supporting necessary certificates. This is a process, Mr. Maraj. This is not somebody sitting down by the desk and say, Paria is going to do the JSA. In that process, the specialist contractor is expected to bring the specialist risk and the challenges that has to be able to execute
Could you
that job.
show me in these rules where what you're saying is stated?
Like everything else, Mr. Maraj, the rules are the rules. The way the execution of the process is also important to how the rules are operated.
Would you agree with me that what you're telling us not stated in the rules?
I don't think it has to be stated in the rule, Mr. Maraj. I think there has to be a distinction between the rules and the way the process is organized to have the benefit of the rules make sense.
Okay.
I think it's unreasonable not to think about the process.
Okay. Look at 5.2
Yeah.
on page 29. See the rules define a competent person?
5.2
on page 29.
on page 29. I am seeing page 14. Is it 29 at the...
Yeah,
okay.
this-
29, yes, 0029.
Yeah.
Okay.
5.2, you see a heading, competent person?
Yes.
A competent person in Paria's permit to work system is an individual who has the required training, knowledge, experience, qualifications to identify the hazards and to develop effective precautions for high hazard activities such as etc. etc.
Yes.
Right? Mm-hmm. Now, Paria decided that LMCS was a competent contractor.
Yes.
Correct?
Yes.
A competent contractor
Yes.
would be expected to identify, as it states here, the hazards and develop effective precautions.
Yes.
Would you agree with me that based on the works which were done in this matter and the documents which were submitted, the hazard of delta P was not identified and precautions for that activity was not also identified?
Well, I want to deal with the two things separately.
Okay.
The competent person, and then I want to deal with whether these documents were supplied or not. I think that's two different questions.
Okay.
Right? So LMCS was identified as the competent contractor to be able to execute that job. Why? Simply, there's no better proof of competence than having done it before. LMC had safely executed this job not more than a year ago or around a year ago on the same pipeline bearing the same risk, using the hyperbaric chamber, using the same badge, using most of the same people. That, to me, helped to define that the competent person was LMCS. Now, as part of whether that competent person in this job would have identified that risk, it was not identified. So I don't want to confuse the two.
Okay, but let's take what you say about a competent person.
Yes.
And you are relying on the fact that LMCS did these works before,
Look,
right?
and, yes, and that's a fact.
Okay.
Right.
But we do not know, from the evidence that is before us,
right,
we do not know the exact, what were the exact amount of liquid in the pipe at the time in those works. Mm-hmm. We do not know whether those works had a similar, had a liquid in the pipe to a certain extent that a delta P could not have occurred. So we do not know from the evidence that Paria has produced what those works, even though there was a hyperbaric chamber and there was a similar pipeline works, we do not know the details of those works. So what I'm asking you, you would agree with me that the fact that a contractor would have done work like this on a pipeline using a hyperbaric chamber, that in itself is not sufficient to determine whether a contractor was competent, according to these rules, to do a particular job.
I disagree with that.
You disagree with
that?
And
let me tell you why I disagree with it. All right? So I know we don't have the exact facts, and I wouldn't pretend to know them exactly. But what I could say in principle, there are a few things at play here. One, there's the use of the hyperbaric chamber. Two, there is liquids in the pipeline that we needed to empty to be able to get to the point in the riser where we had to cut. So that pipeline also had to be drained to some extent. Three, that the potential for DP would have existed in that job no differently than it existed for this job once that hyperbaric chamber was pressurized. 4, very similar people worked on that job who worked on this job. So there may be details that are different, but broadly, the job required the same skill set and the same thought processes to be executed.
Before you move on, can I just be clear, please? You've identified 4 reasons.
Yes.
Use of the hyperbaric, reasons why you say it's not a matter for Paria, but a matter for the contractor LMCS, right? Yes. The use of the hyperbaric chamber being something which is unique to them.
Correct.
The removal of liquid from the pipeline.
Yes.
Draining or partial draining of the pipeline.
Yes.
Something which you were responsible for.
Keep on going. I'll come back to that.
No. I'd like the answer now, please.
I would say
was your company responsible for the removal of the liquid from the pipeline?
I would say our company was responsible for the process and the system by which the liquid would have been removed from the pipeline.
Well, I don't understand that.
All right.
I think you're taking the oil out of your
No. That's it. And I think you hit the nail on the head. Because we are going to be able to, as think about it this way, right? We have a pipeline that is a system that is going to be worked on. The pipeline is a system that we are going to work on.
I just want an answer, if I may, please. All of this, I anticipate, is going to be gone into with some detail by Mr. Maharaj. I simply want to know, when I make this note of what you've said, I need to understand it when I go back over it.
No, fair enough.
So I need to understand, you're saying that the reason why it was necessary to rely on LMCS speciality, special abilities was because of the use of the hyperbaric chamber. I get that straight away, all right? The second point you raised was the removal of liquid from the pipeline, or partial removal of liquid from the pipeline, which, as I understand it, is your responsibility.
Paria had a role in ensuring that liquid was removed from the pipeline.
No, not a role. Was it your responsibility to remove the liquid from the pipeline or not?
Let me say yes to that.
Thank you. Right. And then the third point you mentioned is potential for Delta P existed.
Yes.
As an issue, and that presumably was an issue in the previous job as well.
Yes.
And was not identified in that job either.
Well, we'll have to go back to check. Maybe, I'm not sure. I haven't looked at it.
Well,
so that's
all
something
the
we could
evidence
test.
suggests that that is the position, right? So neither LMCS nor you, Paria, I don't mean you personally, but Paria recognised a Delta P issue in either job.
I would say that's probably true.
Right. And then, and the fourth reason you gave for it, which I think is sort of allied to the others, is that similar people worked on a similar job.
That's correct.
Right. So so that I understand, those are the reasons why it's important, you say, to rely on the expertise
Correct.
that they were bringing to bear.
Correct.
All right. I'll leave it to Mr. Maharaj.
Let's go back to the permit to work rules a bit, right?
Sorry, Mr. Maharaj, there was a further question. I made a note of it. I didn't ask it. And so who do you say the competent person under your own rules was?
The competent person would have been the expert contractor that we brought in, or the specialist contractor.
Right, not anyone employed by you.
Not anyone employed by us.
To name an individual, the competent person was who?
LMCS.
As a company.
As a company.
They were the competent person.
Yes.
Right, thank you very much. Thank you, Mr. Maharaj.
Mr. Morvid, I take you to page 28 of the rules. Core Bundle 1. See the heading applicant?
Yes.
Would you agree that the applicant for these works under these rules was Paria?
Yes.
And it says the applicant is a person who initiates the job activity by completing Section A, etc., etc. The applicant must have the necessary competence to execute the job or to supervise the execution of the job. He shall be knowledgeable of the hazards associated with the job and the necessary controls for these hazards. He shall be responsible for the job and for the safety of the people who work on the job. So those were the responsibilities of Paria in respect of these works.
But I agree, but let us understand how the hazards are identified. The applicant, the hazards are identified through the process where the experienced or the competent contractor and the operator works together to identify the hazards. There's a process by which this system works that allows both the knowledge of the competent contractor or the competent person, the applicant or the operator, to be able to identify the hazards. It is unreasonable to have any company understand every single hazard every single day of the job. I mean, that is just not a request. That's just not something that makes sense.
Mr. Mohammed, there may be a process, and there probably is a process, but I cannot find anything in these rules which talks about these duties that I just referred to you as. Two, these duties, anything that you are saying are contained in these rules. And I'm going to give you the opportunity. The explanations you are giving us today, could you point to any of these rules which say so?
I can't point to it specifically in the rule book, but as I said, with any rules that you have, there would be a process by which those rules are executed. I don't think rules stand on its own. I don't think that's just a fact of how things operate. There is a process by which things are executed and work is done. Now, whether that should be detailed in the permit to work system,
have told us that Paria didn't have the necessary expertise for this work.
Yes.
So would you agree then that it did not have the necessary expertise to assess whether the documents submitted by LMCS were adequate for the work?
I would argue that, or I would say on its own, Paria would not have had the competence to be able to do that, and that's just the fact. I would also say that Paria has a permit to work system and a permit to work process that encourages and facilitates discussion between the competent contractor and the operating company, whereby those risks are identified and mitigated.
So, according to what you were saying then, you were saying that in this matter, notwithstanding the permit to work rules and whatever it says, that Paria depended upon the expertise of LMCS in respect of the risk assessment, the job safety analysis, because it did not have any expertise to do that, and it relied entirely on LMCS assessment.
I would say that Paria would have expected a competent contractor to bring forward the specific risk that was associated with the execution of that scope of work.
Okay, let me ask you this question. As general manager,
yes,
on reflection,
yes,
and what happened with these documents for these works, do you regard LMCS as a competent contractor?
I mean,
a competent contractor for these purposes?
We hired LMCS based on their track record and the competence they demonstrated to do a very similar job on the very same system a short while ago. They were, hold on, give me a chance. Right? We hired them based on that and the documents that they submitted. Now, the root cause of the incident and why the incident occurred, I think it's more than just the competence of the contractor. I think there needs to be a little more understanding of what was the critical factor that caused the incident to occur before I answer that question. What actually happened? What was the critical thing that changed that caused this incident to occur? And why did that change take place?
Okay.
Well, we're going to determine that in due course. But I do want to, if I may, please, pursue that a little further. You see, what Mr. Maharaj has been asking about is the applicant.
Yes.
Now, the applicant is described in your own document, the document that is the permit to work procedure that your firm effectively put in place.
Yes.
Right? And it assigns various roles to different people and different responsibilities to different people.
Correct.
And the purpose of that is so everybody understands what their competencies are and what their responsibilities are.
Right.
Yes? So, in paragraph 5.1, it describes who the applicant is, doesn't it?
Yes.
It says, so that we're clear about it, the applicant is the person who initiates the job activity by completing Section A of the work permit.
Yes.
Right? Or the certificate. That's the first sentence. Second sentence, the applicant must have the necessary competence to execute the job or to supervise the execution of the job. That's one sentence.
Right.
All right? So the applicant himself, in this case, was who? It was, if you can't remember, Mr. Houston Marajat Singh.
Yes.
Yes? He is the person described in this rule book, if you like, your rule book, as the applicant.
Yes.
And it follows that any ordinary reading of that sentence, that the applicant, Mr. Marjad Maharajad Singh
Yes.
is that he must have the necessary competence to execute the job, right? Or supervise the execution of the job, right? Now, given that is the position, is it not, in its ordinary and plain reading, his responsibility to ensure that such hazards as might exist are identified?
Right, and it's all right if I take you to the next statement?
Yes,
The
well, I'm
next
going to read the
sentence?
next sentence,
Next
because the next sentence, which is equally important,
Right,
he shall be knowledgeable of
Right.
the hazards associated with the job
Right.
and the necessary controls for these hazards.
right,
And he should be responsible for the job and the safety of the people
right.
working on it. Now, is it your position that he only gains that knowledge from the contractor?
It is my position that the knowledge of the hazards in a specialist type job
Yes.
is gained through the process of engagement with the contractor, who would bring specialized knowledge and specialized understanding of the risk and hazards associated with that job.
I think I understand you then. So what you're saying is his knowledge is not independent of the contractor.
That is correct.
It is linked to the contractor.
That is correct.
So if the contractor's wrong, he's going to be wrong.
If the contractor is wrong on the specialized knowledge, there's a chance that he could be wrong, yes.
Well, almost inevitably, if that is where he gains his knowledge from. So the sentence which says the applicant must have the necessary competence to execute the job, clearly he didn't. Mr. Maharajad Singh is not your, is he your employee, isn't he?
Yeah, it's Paria.
He's Paria through Kenson, yes.
Yeah,
Paria.
Kenson employ him. He works for Kenson, but Kenson are employed
Yes,
by
yes,
you
yes.
to do those jobs, right? So to all intents and purposes, he's Paria, correct?
All right, I wouldn't argue that.
Good. So he, being the applicant, must have the necessary, I mean, these are your words, must have the necessary competence to execute the job. Fact is, he didn't have the necessary competence to execute the job, did he? He didn't.
He didn't on his own, I would say, without the experience and the knowledge of the contractor, would have complete experience.
See, I'm struggling a little, if I be frank with you, I'm struggling a little to understand this whole concept of an applicant. If he doesn't have the necessary competence to execute the job himself, or to supervise the execution of that job, because he doesn't know how to do the job, what role does he actually do? If he's just dependent on the knowledge from the contractor, then what is he actually doing?
So what the practical world that we live in the execution of work, Chairman, is, as I said, there is no company, no applicant that will be able to identify every single risk that is associated. So what is done, and that is why we have a permit to work process, is that a system of engagement with the contractor and with the applicant or the company is set up to be able to identify and be able to work these risks.
Mr. Mohammed, you've said that several times in answer to Mr. Maharaj and to me. What I want to understand is what is his actual role? What is if he can't do the job and he can't supervise the execution of the job because he can't do the job? I want to understand what the applicant's role actually is. What is he actually doing? If he's totally dependent on information provided by the contractor himself.
I never said that he was totally dependent, right? So remember, there are two types of risk, and there is the supervision of the job. The two types of risk are the obvious risk. So LMCS is coming to work on our facility.
Yes.
We transport cargo, we use ships, we have high volumes of inventory of hydrocarbons, we have all of that stuff.
Pause for a minute, and I follow all of that.
Right.
Why would you make the applicant in a work permit system this individual? Mr. Kenson, somebody from Kenson, or employed by Paria? Why not make the applicant the contractor?
That's a good point. Very good point.
I mean, if it's his responsibility, if you're reliant on him, as you've been at pains to tell us and Mr. Maharaj, why are you making this other person do anything?
It's a good point.
I simply don't understand it. And I mean, at best, would you not agree? It is ambiguous, to me at any rate, reading that.
Yeah, I think it creates some ambiguity, so, I think you made a very good point.
I simply don't understand the point of having an applicant unless that person, I could see it in other circumstances, but where you are wholly reliant on the contractor being able to identify the problems that might exist, why not make that person the applicant?
It's a very good point, sir.
Okay, thank you very much. I'm sorry, Mr. Maharaj. I just needed to understand.
Mr. Mohammed, as general manager of this company,
yes,
if, as you said, Paria did not have the competence to do this job or to supervise this job, why Paria did not employ an expert to advise it in respect of these documents which were submitted by LMCS as a sort of client representative, an expert to assist Paria in discharging these responsibilities?
Mr. Maharaj, there are a number of options that are available. The option we choose to execute this job was to bring that expertise through the contractor that we hired. I'm not saying that what you're saying is not an alternative, but what Paria did, and the expectation is that that competence and that expertise would have come through the contractor who had experience in executing a similar job before.
But, Mr. Mohammed, I want you to try and understand my question.
I understand your question very clearly.
If, according to the permit to work rules, the applicant here is Paria, and Paria had the responsibility of ensuring that necessary competence to execute the job or to supervise the execution of the job, and you as the general manager, no, Paria did not have the competence to do that, why Paria did not consider having an expert to advise it in respect of the documents which were submitted for these works?
That would always be a consideration, Mr. Maharaj. In this case, as I explained, Paria chose to go with a contractor who had a track record of executing this very same work not longer than a year ago.
But you would agree with me, I think you agreed with me before, but tell me, you would agree with me that these works had serious hazards which could have caused persons to be injured, and in this case, 4 persons lost their lives. So this was dangerous operation. Wouldn't you say that?
Mr. Maharaj, it's very unfortunate and regrettable that 4 people lost their lives. I can't explain to you how it feels to be sitting on this end of the microphone in a situation like that. All right? And I have been in this industry for all my life, since 1985. But I also want to add that we do dangerous work every day. Today, while we sit here, I have guys who are standing on top of a tank that is 90 feet high doing welding. That's dangerous work. I have guys who are working on 12,000 volt systems. That is dangerous work. So there was no, I would say, this was specialist work requiring specialist risk. But we conduct dangerous work every day.
I agree with that.
Okay.
But, Mr. Mohammed, all that I'm asking you, if you know that Paria is doing dangerous works which could cause injury to persons or even death, would you not think that in the exercise of your duty of care, 2 persons, you should have had an expert to advise it in respect of these documents which were submitted by LMCS?
Paria has adopted a system for work that includes the hiring of competent contractor and a permit to work system through a process where those risks are expected to be identified. I am not discounting what you said, Mr. Maraj. I mean, it's very good consideration, but I am saying it's not the only consideration. We have a process by which we manage those risks. Now, if that's something for consideration, then that's fine. But there is a process. What I don't want to leave on the table that has to be said is that there is a process that Paria has in place to allow these risks to identify and a particular approach.
If in this case, right, Mr. You see, I'm not sure that that's right, is it? Because if we just go back to what I was asking you and what Mr. Maharaj asked you before, I mean, if you read paragraph 5.1 and what the applicant is supposed to do, if that person is somebody from your firm or someone you employ through Kenson, is not the contractor entitled to think, well, if we've missed something, they will pick it up? It's a two-way street, as you put it yourself. Why would it be that you are entitled to be completely reliant on the contractor, abrogating any responsibility yourself for something that might be not an unreasonable risk, when one reads what the applicant's job responsibility is? Why wouldn't you think, if you were the contractor, well, they're taking on some responsibility too. They are saying, we will employ an applicant who must have the necessary competence to execute the job or to supervise the execution of the job. And he should be knowledgeable in the hazards associated with such a job. I mean, wouldn't the ordinary reader think, well, I've got some cover here?
As I said, the perspective is not lost, Chairman, or the perspective is not lost from Mr. Maraj. The perspective is not lost.
All right. Well, thank you for that. I think we'll take a short break now.